You are against a stay application.
No, in one day, my lord, 3 orders were passed, same order. There is no difference, my lord, in the order. In one day, 3 orders were passed. I have challenged those 3 orders only.
What is the order? That is what we are asking.
Order, my lord, they have dismissed my application, and
OA has been dismissed.
it is dismissed. Everything was recorded and it was dismissed. The main part is the government order, where, my lord, I have challenged that a committee which has been framed to assist the transfer, my lord, that contain, my lord, my rival association. That was a part of the challenge in the government order itself.
Oh, it's arising out of a transfer matter.
My lord, but still, my lord, ex facie malafide. My last time the lordship has seen and said it.
We don't remember.
Well, lordship order is here. Twice I am before.
So we should remember all the orders. We don't remember only this. Not this week. Cannot be this week. Sorry. You go and join, then you move the application. Cannot be, sir. We'll see. We'll see. Monday it will come. Monday it will come on the list. We'll see. Not sorry, sir. You mentioned on Monday transfer matter. As it is, I'm not inclined to interfere in this. Only after you join. That is the law. We'll see when it is taken up. Call the list. We don't know whether it will now be taken this side or not. Maybe not. What we are saying, you must have heard. We cannot. There are too many matters pending. All those matters have to be. We just can't take up any more before the holidays. Please try to appreciate what we are saying. Yes.
Lordship, may I be permitted? Your Lordship, may I be permitted to mention a contempt matter was specially assigned to Your Lordship and Lordship Prosenjit Bishash. It was due to come. It was on the list on 29, but Your Lordship could not take up due to the
Yes,
unfortunate.
because that day bench was not.
Yes.
We'll see. What is the case number?
CPAN 820 of
We'll see.
2020.
We remember that bench could not be taken up that day because.
Kindly, Your Lordship, if
We'll
it
see.
could be taken
Don't
up.
worry. Yes.
Grateful.
My
Your
lord, I wanted to mention, my lord, petitioner, it is contempt application. He is going to retire in December 2025. He is in great difficulty, my lord.
Mention after the holidays.
Hey, my lord.
Yes. Yes. We cannot understand, sir, what you are saying. Give us, let us. What is the main relief in the writ petition? Use your mic, please. We are asking you what is the matter pending in the writ proceeding. In the writ petition, what is the order under challenge? Review. What is the urgency? We'll see.
My lord, in this
Next week, list.
withheld, my lord.
Madam, you mentioned is to return in December. We have heard you. We said mention after the holidays. December is not after the holidays? Yes, call the list. You think we didn't hear you? We just did like this.
Original side listed matter under heading to be mentioned. Bhaskar Gupta.
Yes.
Some time has passed by.
Yes,
So should we keep it in the next week?
Lordships, please. If your Lordships wish, I can give a brief recap, or if your Lordship.
That's all we want, just
Yes.
a bit.
Yes.
Any day in the next week, you tell us.
It's my Lordship's convenience, my Lord. Monday.
Both of you, convenience of both.
Monday. Sombar Court. Lordships.
Monday, we have any matter at 2 p.m. Monday, 2 p.m. we have any matter? उस दिन तो वो लोग तो खत्म ही नहीं करेगा क्या What order? Tuesday? So we can keep this at 2 p.m. এইবার অনই ছিল
On Monday.
Monday.
Lordship.
Very.
At 2 p.m.
Recapitulation.
Yes. Would your Lordships desire a brief notes of arguments, my Lord? We can file.
Can if you want.
Lordships.
We are not
Then
able.
perhaps if it's your lordship's pleasure to allow us to file a written note, a short
Just
note.
saying you may if you want. We are not.
Because my lord, in that case, my lord, I would be in some difficulty during the weekend, my lord. So perhaps I wouldn't be able to make the note.
Tell us. We are saying give us. an
Then
agreement.
in that case, my lord, if it could be on Wednesday or
I do not have any problems. If your Lordships keep it on Wednesday. Wednesday.
17th. 17th. my lord.
Grateful.
Item number 1.
Two 204. Is your rate हाँ,
Item number 3. 325.
On the age of 25, I am for the
this is the recall application. Review, recall, what is it?
Yes, have made it there was an error on my part, Your Lordship. At the outset, I admit it should have been a review.
But it is a recall.
Yes, I have made a recalling application.
Yes. Why?
Kindly sees my recalling application. I am treating this as a recalling application as of now. Kindly see His Lordship's order, which was passed on the 30th of January, which is page number 26, annexure R1.
The application. Where is the application? WPST 240. Give that. R by 1.
Yes, R1, page number, kindly comes to page number 31. Paragraph number 15. May I kindly be allowed to read?
Yes.
In the present case, the petitioner is claiming the counting of the past temporary service rendered since 1981 to be counted as qualifying service under Rule 17 of the DCRB rules. The petitioner number one's husband was in continuous temporary service since 1981. It is also not in dispute that after serving in temporary service for 16 years, as such, her husband was made a permanent state government employee with effect from February 1997. Thereafter, he has served the state government for 7 years, 4 months regularly. Paragraph 16. The petitioner, therefore, is entitled to count such long uninterrupted temporary service which culminated into permanent government employment as qualifying service for the purpose of grant of benefit under the DCRB rules. Such conclusion is supported by decision of the coordinate bench in the case of Nimai Chandra Chatterjee. Now, Your Lordship, the writ petition has Nimai Chandra Chatterjee's judgment. It starts from page number 89. of the WPST 240.
No, then what is the error apparent on it
Yes,
that
yes,
requires the recall or review that we
We-
are asking? We are
yes,
not
we-
going to re-argue the matter.
Yes.
We hope you are not.
Just on the point that from the period 1981 to 1997, which was regularized with effect from the petitioner's husband was regularized as a temporary khalasi, work charge khalasi from 1997 with effect from 1996. The period from 1981, due to the existence of a finance circular dated the 25th of March 73, that period cannot be counted as a temporary service. That at that point of time he was a muster roll employee, and that is why that period is not qualified to be taken as period which can be counted in temporary service. Hence, he does not qualify, and he superannuated in 2004.
So you are relying upon which decision of the state government?
Nimai Chandra Chatterjee, this
No, no.
was relied upon by the petitioner. I am relying upon a judgment by the
No, no,
honorable
not
apex-
judgment, not judgment. We are not, you are not re-arguing. Let us be very clear. We are not allowing you to re-argue the case. You say some particular government decision is there,
Yes.
that muster roll is to be treated differently. Where is that?
In my recalling application, your
So
lordship.
it was not before the writ court.
No, at that
It
time.
was neither before the tribunal nor before the writ court.
I kindly sees
No, no,
In the
first tell us.
in the tribunal, it was before the writ.
It was before the.
before.
So what is the date
This is at page number 35, annexure R2.
of the recall?
Yes, of the recall. Page 36. Roman numeral 4. Three and 4.
Yes, so how is this relevant? What is the relevance of these two provisions?
Yes.
How it is relevant?
Because your lordship, he was a muster roll employee. He was a daily rated. Muster roll employee is a daily rated service. It is I render a work. It is a payment which is made to me on a daily basis. So this period till from 1981 to 1997, he was a muster roll employee. So this cannot be counted as a qualifying service for temporary service. He became a temporary khalasi in the year 1997 with effect from 1996. So this cannot be counted in terms of this GO.
He became a temporary khalasi in 97.
97.
And when was he regularized?
In 97.
So once he is regularized, how can he be a temporary khalasi?
Kindly understands. Even muster roll employee, temporary employee, and then permanent employee. There are three sets. So he was first a muster roll employee, then a work charge khalasi, and then he retired as a work charge khalasi itself. Kindly allow me to place two judgments.
He was regularized. What do you mean he retired as a work charge?
No, your lordship, he was not made permanent. He was given. Suppose may I help demonstrate with an example?
No example. Let us see the facts. He has not been regularized. Where have you said in your reply before the tribunal that he was not regularized?
Kindly sees the reply.
Yes. Just show us that averment that he was never regularized.
Page 57. Page 57, Your Lordships. At the outset, I submit that the instant application is misconceived and is not maintainable in law in view of the fact that the applicant was initially joined as work charge khalasi and therefore he was absorbed in terms of government order number this dated 13/3/1996 of the Labour
So
Department.
what does absorption mean?
There is a stage, Your Lordship, he was absorbed.
What is that? What does that mean? What is your stand about that absorption? What status he has after an absorption? What does your reply before the tribunal say?
That's what I'm reading.
Yes.
He was absorbed in terms of government order number 100 EMP 1M 17779T dated 13/3/1996 of the Labour Department, Government of West Bengal. The superintending engineer, this is a small reply, I may kindly be allowed to read. Irrigation and Waterways Directorate issued appointment letter in favor of the applicant.
Madam, we are not asking you to read the entire thing. You said he was not absorbed, he was not regularized. Where have you said that he was never regularized? Tell us. There's no question of going through the entire thing again. We have heard it. We may have passed a wrong order. It is subject to appeal. We don't know what is happening. You said he was never regularized. So if that is an error from the record, show us where you have said that he was not regularized.
Yes. Permanent but in temporary service. Kindly see the definition of master role once.
That's not required. You said he was not regularized. So if that is an error of record, show us. If that is not an error of record, then where is the question of doing anything in a recall or a review? We are not going to rehear the matter that what was his status prior to absorption. We have relied on a judgment. We have passed the order based on that judgment. We don't know. It is up to you to get the order tested or judgment tested before whichever forum. You cannot argue an appeal in the garb of a review or a recall.
अरे टेम्पररी सर्विस है वो
Absorption 18 months complete হচ্ছে না
ও আমি জানি absorb হয়েছে 1997 তে No, I'm not saying but the designation muster roll. No, kindly seize your lordship. Kindly allows me a few moments. Kindly allows me just one or two judgment that I want to place. That why I'm saying that this period cannot be counted. This is what I'm just trying to that the petitioner who has applied for pension scope of review is that lordship has held that from 1981 to 2004 he has been in continuous service, but the period I'm not trying to re-argue. Your Lordship kindly bears me for a few moments. This is what I'm trying to convey to your Lordships, that the period which has been counted as continuous service is not one part of his. Lordship, the point of his being muster roll was not ventilated when this matter was before your Lordships. This came to us much later. Since we were not given the opportunity, please, since we were not given the opportunity of filing our affidavits, this I am admitting that this point that he was muster roll in the first stage, this did not come to light at that point of time. Yes, reply was before, but that then paragraph 3, no, kindly comes to paragraph 3 of the reply 58. Fifty-eight of the WPST. 58. ছাড়ো না, আমাকে আজও করতে দাও না, তুমি যে সময় বলো আমি ইন্টারাপ্ট করি। And first paragraph, Your Lordship, this from 6th line. The Superintending Engineer, Western Circle 1, Irrigation and Waterways Directorate issued appointment letter in favor of the applicant. Vide order number 285 dated 21 to 1997, and in pursuance of the said order, applicant joined in the government service on regular basis on 1/5/1997. The date of birth of the applicant is 17/8/1944, and on the basis of that, he retired from the government service on 31/8/2004 after attaining the age of superannuation. Therefore, the span of service on regular basis of the applicant is 7 years, 4 months. In terms of order number 2255F dated 23/22/3/1973 of the Finance Department, Government of West Bengal minimum qualifying service for getting superannuation pension is 10 years. As such, the applicant is not entitled to get pension.
You have used the word muster roll. Point out from your reply file there in the tribunal. To describe the petitioner anywhere in your reply.
58. In accordance of Labour Department, third paragraph.
Yes.
Government of West Bengal read with memo number 20933 CIE dated 16/4/1996 of the Director of Personnel and ex officio Chief Engineer, Irrigation and Waterways Directorate. The Superintending Engineer, Western Circle 1, Irrigation and Waterways Directorate issued appointment letter in favor of Kshitish Chandra Naskar, ex-MR worker. Vide his order number 285 dated 21 to 1997. In pursuance of the said order, Kshitish Chandra Naskar joined in the government service on 1/5/1997 FN in the scale of pay 800, 15, 920, 18, 1188, 21, 1265 plus allowance as admissible from time to time.
Everywhere you have described him, you see the first paragraph, paragraph 3, X work charge khalasi. Third paragraph, X work charge khalasi. Last paragraph, X work charge khalasi. Everywhere. This is not even mentioned anywhere that he was ever appointed as on muster roll.
May I just, for the sake of argument?
Now you are trying to make out a new case that he was appointed as a muster roll on a muster roll.
No, Your Lordship,
How
it's
it can
not
be
this.
in a review or recall application?
Even when I was arguing before Your Lordship in the WPST matter, this was not communicated to us, and that is
What
why.
communicated? This is the stand in black and white before the tribunal. This has been filed by you based on some, perhaps probably based on a well-considered decision to file this reply before the tribunal. It has been filed.
But
Now we cannot
ex-MR
permit you to
worker,
make out a
the
new
word-
case.
The ex-MR worker is there, Your Lordship.
We don't know what that MR worker is.
Sir,
We don't know.
from
You have said so many words. Ex work charge khalasi everywhere. Nowhere it has been stated. We don't know what is ex-MR worker.
kindly, Your Lordship, just allows me to place 2 judgments. After that, Your Lordship.
No judgments, madam.
And kindly allow me to just point out before Your Lordship that Nimai Chandra Rai Chatterjee does not apply to us.
May not. We are saying we may be wrong. We may be wrong. That is not a ground for us to look into the matter like an appellate court. This is a way beyond the scope of review or recall you are arguing. Cannot countenance such an argument. It's such a limited scope in a review and recall, and you are arguing as if we are re-hearing the matter. It's not the scope.
Kindly, Your Lordship, kindly just.
Take down. The
kindly see paragraph, page, 4, small b, page 3. Opposition.
Paragraph.
WPSC number
You are in WPSC 118.
four,
Paragraph.
4.1. Yes, small a. There are the master rule, casual delineated record prior to being absorbed as a work charge, Construction Division under Education and Water Directorate, Government of West Bengal. Then, in terms of the Labor Department memo number 13 March 96, relating to the Director of Personnel and Exceptional Secretary Education and Waterways, Kader Ali was given till then engaged as a master role delineated absorbed by demoted 81st February respect of work charge, Khalasi under work charge, installment in the scale of rupees such as what is master role? The kindly see that is at page.
So what is the difference? Now tell us the difference.
Master role. But kindly
Page
see the
20.
page 20. Page 20.
Page
Page 20 of the reading note.
opposition.
Definition of master role.
No, we are not asking you to define it. Why he should be deprived of the service which has culminated into a regular service in terms of your government's decision?
Yes, kindly see the absorption.
Yes.
Kindly see the absorption at page 25.
Page
Page 25.
Given of annexure, our opposition also.
No, but his absorption. His absorption, page 25 of the definition.
25 of the rate petition.
Dated of February 1997. Got it.
Now where is the government order of 13,396?
96. Page 11 of my opposition. That is permitted place.
Let us get it first.
Features to be followed in the matter of absorption of casual and such other categories of workers and discontinuation of other engagement, therefore under the government of West Bengal. Then, the principles to be followed in the matter of absorption of casual and such other category of workers engaged prior to 3rd August 1979 in the regular establishment of the government and all also discontinuation of engagement such workers 3rd August 1979 were earlier decided by the government as embodied in the Labor Department memo dated 3rd August 1979. Principles for engagement of such workers were also framed in Labor Department memo dated the government decisions for prohibiting further engagements of workers were regulated from time to time, ending in the Labor Department's notification dated 9th December 94. In spite of that, it was brought to the notice of the government that some department resorted to engage such a. Then, for some time past, the question of absorption of casual and other categories of workers engaged from time to time in the various establishments under the government West Bengal in regular establishment. Also, question of instructing such engagement have been under active consideration of the government. After careful consideration of the matter, the governor will please to decide all such workers, including seasonal workers, any type of work of any establishment under the various departments of the government, except the Home Department, including Transport Department and the Industrial Construction Department during the period from 4th August 1929 to 35. To engage may be absorbed on temporary basis in any regular establishment of the state government subject to the fulfillment of other terms and conditions laid down on the Labor Department memo dated number 79 at DMP dated 3rd August 79 dated memo dated. Then, the service of such casual workers engaged prior to 3rd August 19 up to 31st December 79 who are not eligible for absorption as per norms laid down in the read above are required to be retained in the interest of the public service, the particular subject. These casual workers should be ordered to the labor department. For particular concerned cases of such casual workers engaged during the period from 3rd August 1979 under
The distinction that you are trying to draw for a muster roll,
master law.
you read paragraph 5 of this.
Henceforth, no appointing authority in an establishment of the state government shall engage in seasonal or casual workers, whatever may be the called.
Yes, this is important. This is important. Whatever it may be called, by whatever name, whether daily rated, muster roll worker, etc. All are in the same bracket.
Kindly see the definition of the master.
Forget about definition. This is your decision. This is your decision. And you are trying to now indulge in hair splitting that because he is called muster roll, he will be deprived of any benefit and other will not be.
Emphasis on paragraph 5.
So paragraph 5, just read it.
Yeah.
This is your decision.
No appointing authority in any establishment of the state government shall engage in seasonal or casual worker.
Whatever it may be called. And thereafter they specify that it may also be called daily rated, muster roll, everything, everyone.
Without the prior concurrence of the labor department and finance department for a period exceeding 15 days, either intermittently or continuously, any violation of the instructions will render disciplinary actions against the delinquent employee. Can you see the definition of
Master role.
master role?
Not required, sir. That's not required. That is not at all required. They may be defined whatever. This is your decision. You take them in one bracket for the purpose of regularization.
But can you see the definition?
Why? Why? How it is relevant?
Yes, yes, sir.
Why? This is 93 decision. When is that definition?
Page 2.
What is the date of that definition? We are not going to just see everything that you want to show us. Has to have some relevance. Your regularization is in terms of this 93 decision, memorandum.
No, no.
Yes, it is. Just now you have read.
96 memorandum. 96 memorandum.
Huh?
Can you see that page 25 of the decision?
Sir, you please.
March 96.
Huh? So that is what we asked you to show us. This is,
March 1996.
so this is 30th March 1996, which you are just reading. And in this, they have all been put in one bracket.
No. Government absorption memo, I just am tracing.
This is the absorption memo at page 11, which you have just read.
Yeah. No,
It,
page
it
25.
places all of them in one bracket in paragraph 5.
Except piece rated or daily rated work.
No,
This is the memo
page
of
36,
finance.
page 36 of the decision.
না এটা হচ্ছে গীতা নস্করের
No,
গীতা
no.
নস্করের
In terms of the GO number 100 EMP dated 13 March 96, EP number dated 14.
Now what are you reading? Tell us also what you are reading.
Reading page 25 of the decision.
Yes, we have seen that.
Yeah.
In terms of, yes, you read.
Yeah, 100 EMP
Yes.
dated 13 March.
Now where is this 100 EMP?
Just at place before the-
And what does it say in paragraph 5?
And 16th April 96, the following master role.
yes
Master role workers,
So,
those who are
So-
master role worker has been absorbed as a employee of the work charges.
yes, they have all been treated the same, whether daily rated, muster roll, casual, temporary, all.
He has been absorbed, but kindly say the language, he has absorbed and appointed in the post.
So therefore, what you are arguing is the nomenclature which he had prior to his absorption is not relevant. For the purpose of absorption, it is not relevant. How it is relevant?
What kindly see.
before absorption
See, this you are reading an absorption order. The absorption order is under a policy which is in 100 EMP.
100 EMP.
In 100 EMP, where is the difference?
Kindly see, where is the?
There is no difference.
But when he has been absorbed, what is the terms and conditions of the?
That is a different thing.
Just
See, what therefore, the same argument you can advance for casual, the same argument you can advance for temporary, the same argument you can advance for a muster roll or whatever. There is no distinction.
get respect one another. But kindly see the language. They are hereby absorbed and appointed in the post mentioned against the each under work charge estimate against post created under 97. If post is created in 97, how they are earlier period could be
Prior
counted
can be
for
counted.
So therefore, this is an argument which you can advance for everyone, not only for muster roll. This is what we are saying. There is no magic in nomenclature muster roll.
Kindly excuse me, Malak, post was sanctioned in 97.
Correct. That we have understood what you are saying. Prior to creation of post, how he can get any benefit?
Yes,
This is you are trying to say.
Yeah.
So this will apply for anyone. What is the magic in the nomenclature? That we fail to understand.
whether that period should be counted or not.
So that will apply to everyone, whether master role, casual, temporary, everyone. How they can count?
Master role is different.
What maybe, but once it is absorbed,
Then they should not have used the nomenclature master role, work chart, and the casual.
because that is a nomenclature attached to the individual. 100 EMP has been issued by you
Yes.
in 96.
Yes.
You were facing a difficulty that muster roll, daily rated, casual, or have been working for a long time in perennial source of work. We have to absorb them.
Yes.
You say whatever may be the nomenclature, they will be absorbed subject to these conditions. You have found this person to be complying with those conditions.
Yeah.
Thereafter, you have absorbed him.
Yeah.
Now, he claims the benefit of the period prior thereto for counting for the purpose of qualifying service.
45%.
You say it cannot be done because in 97 the post was created. How can he get anything prior to 97? So we have said this at least 5 minutes earlier also. What we are trying to understand and we fail to understand is this argument, it will apply to all of those who are absorbed.
No,
It is irrelevant whether they were on muster roll or daily rated, or because paragraph 5 says they are all to be absorbed.
master role and daily rated have different definitions according to the.
And nomenclature is hardly, because your 100 EMP does not distinguish. The policy for absorption in 100 EMP does not distinguish. Paragraph 5 says all.
Can you see the definition of master role? Page 20.
That is not relevant. Now he is not on muster roll. He ceased to be on muster roll in 97. 97.
97.
Correct.
Then Malad, whether that
From
period
the date of
rendered service, when
absorption.
the post was not created by the government.
All right. So tell us one thing. If instead of muster roll, he was labeled as a casual employee, then he would have got prior to 97.
When the post was sanctioned,
Then he would have got prior to 97.
would have kindly consider.
No, kindly respond to our query. You are laying great emphasis on muster roll. Therefore, we are asking you, if the post was created in 97,
For a moment, that master role, casual are same benefit.
yes,
Assuming for a moment.
yes,
For a argument's sake, I'm accepting it.
yes.
Then Malad, if the post is sanctioned in
Correct.
1997,
That we have understood. No problem in that. We have understood. We will consider your submission.
the pension would be counted from the date of creation of the post.
Obviously, that has been your case in every case.
In my case, the 10 years is not completed.
Correct.
Whether that Nimai Chatterjee's case, for the post was there, and here post is not there, post is there from 97. Whether Nimai Chatterjee's ratio of the decision.
Now, where does Nimai Chand Chatterjee say that post was there? Show us.
Paragraph number 2.
Action দাও
ওটা ডিফারেন্ট ওটার সঙ্গে আমাদের
action দাও তো
দিচ্ছি ওটা কোন
Nimai Chatterjee
2. Paragraph number 2, 9.
paragraph 2. The petitioners in this case were employed on different dates as seasonal builders. They were paid monthly remuneration in accordance with the office order issued appointing them in service. The office order indicates they were entitled to payment salary on scale of such and such. Plus, month payment of salary in the entitled to salary of scale of such and such of 380 plus user advertisement. All these appointments were absorbed in a permanently effect from 1997. Their regulation service was effected only after interview and age verification of the production of certain documents.
They were monthly remuneration.
Monthly remuneration.
Daily rated.
They are, in this case, the petitioner is daily rated prior to regularization.
You said that in Nimai Chand Chatterjee, they were against the sanction posts.
You can see the language.
Yes.
The office order indicates they were entitled to payment of.
They were seasonal builders. There is a sanction post of seasonal builder.
Yeah.
Where is it? Show us.
না না আমাদেরটাই নেই।
But in our case, there was no sanction.
Forget about it. From in there, where was the sanction post?
চাকরি করতে পারছি না। মানে monthly remuneration ছিল।
There was a
আমাদেরটা
monthly
daily।
remuneration in a particular pay scale. Monthly remuneration where?
Hmm?
Monthly remuneration paid to whom? In a
Show, don't. You said that in that case there was a sanction post on which they were working since before. Please show us that fact from Nimai Chand Chatterjee.
pay scale is mentioned. If pay scale is
That is no pay scale. That is a some kind of security of tenure under your scheme, granting them the minimum of this pay scale since they are working since long.
no. This pay scale 220 to 600.
Yes.
30. Can you give it to whom? He must that there must be a sanction post or there must be a pay scale.
Show us that there was a sanction post. Your specific case is that in Nimai Chand Chatterjee there was a sanction post on which he was working prior to his regularization. Now show us.
The facts are different in a Nimai Chand case.
That is a different thing. That we will consider.
Yeah.
That we will consider.
Nimai Chatterjee's case is different because
No, but if you have not been able to show us that prior to absorption or regularization, Nimai Chand Chatterjee was working on a sanction post.
No, no, it's not sanction post, monthly remuneration.
monthly remuneration to pay to whom?
All right.
Monthly remuneration can be paid in a
Sanction post people get a monthly remuneration or they get a pay scale. Tell us.
on a casual rate.
Sir, whoever is on a sanction post, he will get a pay scale or he will get a remuneration. So, not a monthly remuneration.
Monthly remuneration to pay to whom?
Monthly remuneration is,
there. Post is there. Sanction appointment.
show us the fact. We will not presume anything.
The petitioner.
We will not presume anything.
Can you see that paragraph 3? The petitioner discharged the same duty continuously without any interruption or break in service from time that they were
Paragraph
initially
number 9
recruited
and
as
11 টা দেখবেন।
seasonal builder till they were retired from service on attaining the age of 60 years. On retirement, petitioners received all dues except the pension and they have not been completed 10 years regular payment of service as annual builders. Then
9
paragraph 9. Rule 17
DCR,
of the
কোথায়
Disciplinary
হবে?
rules defines qualifying service. Dispute that it shall commence from the date of government servant taking charge of the office which is first appointed either substantively or on officiating temporary capacity. Then rule 18. Service of an officer does not qualify pension unless you confirm all the following conditions. Service must be under the government. Employment must be substantive or permanent. Permanent status or quasi-permanent. Service must be paid by government. The condition of Rule 18B stands relaxed by memo dated 2-5 dated issued by the Finance Department 22nd March 1973, which
10-year
stipulates
term.
that government servant who has worked continuously as a temporary employee for 10 years or more should be granted pension and gratuity as admissible.
Temporary
Temporary employee for 10 years or more would be granted pension and gratuity in admissible amount.
our case is a
Employees
master
under the
age
non-member.
dated.
Rule 22 rates are any temporary appreciating service under government follows out without interruption of the confirmation or by declaration of quasi-permanent permanent status in the same and that post that however counts as qualifying service except for the shall however count in full qualifying service except that the period of then the period of service paid from the contingent shall not count. A bare period of the officer rule will operate there are this no doubt. The service rendered by employee on a temporary basis may be taken into account in completing the qualifying service followed immediately without any break. A permanent or regular service. In fact, Rule 17. In case qualifying service being calculated from the date of initial appointment in service, even in temporary capacity, the condition for payment of pension that person should be rendered qualifying service of 10 years for the grant of pension. It is not possible to accept the submission on behalf of the state the service rendered by an employee during prior to spent on temporary service should be excluded for the purpose of recording the qualifying service. In the present case, there is no doubt there was no interruption service. All the employees work continuously without any break since the respective. It has been argued on behalf of the government that unless petitioner appointed temporarily in a sanction post, can't you see the language? Mala, can't you see language? It has been argued on behalf
That is your argument.
of my argument.
That is your argument.
Then can you see the analysis? paragraph
10
20.
years qualifying service now বলে
The what you are arguing before us, whatever you are arguing before us, you are trying to say that there is a temporary status. Unless he is in the temporary status, he is in no position to claim anything.
There is no post at all.
So therefore, only if he is in a temporary status and getting a monthly remuneration, he can claim, otherwise he cannot.
সেটা ওখানে নিমাই
This is what you are trying to say.
But
No.
our case is different.
Yes.
it's a
But
master
he
role
was
daily
getting as a master role worker, not a regular
That
service.
we have understood.
Now, my lord, whether
How that petitioner of Nimai Chand Chatterjee was better than this petitioner, that you have to tell us.
তারা ছিল মান্থলি রেমুনারেশন আর
they
এখানে
were
daily
getting
rate.
monthly remuneration, here there is no pleading, they are not get, they are
That is the distinction. All right. That's all.
Yeah.
And monthly remuneration under which decision of the government?
That is 200 EMP এটা 100 EMP
100 EMP and 200 EMP.
Huh?
এটা 100 EMP the master role
100
Yes,
EMP is
25.
100 EMP is 13 March 1996.
13 March.
1996. Just her place before that.
That
100 EMP.
yes.
Master role daily rated employee, not monthly salary. And there is no post at all.
97
And Nimai Chand Chatterjee, they were all temporary employees.
remunerated
Remunerated in a particular pay scale. That means when pay scale is there, there must be a-
This is the distinction that you are trying to.
qualifying service
and in the present case, he has not 10 years qualifying service has not been rendered. That's the difficulty.
from the date of abstract.
From the date of absorption, from 1997.
You have another copy of this judgment, Nimai Chand.
10 15 minutes extra.
Huh?
I'll make it extra আছে extra 3 হয়েছে
ও annexed আছে ওর মধ্যে
গীতা নস্কর অ্যানেক্সড আছে নিমাই
গীতা in my WPST your lordship it is annexed হ্যাঁ
আমি দিচ্ছি আমাদের উই আর দেখো
তোর কাছে extra আছে তোর কাছে extra আছে আরে
হ্যাঁ
I'm grateful to my landlord.
একটা জাজমেন্ট যদি আমি প্লেস করে দিতাম সুপ্রিম কোর্ট ডিসাইড করেছে
What
এটা দেখান দেখান গুজরাট না না
একটা কপি দাও এইটার একটা কপি দাও এইটার একটা কপি দাও এর একটা কপি দাও
ওইটা তো
না না এইটা
চাইছে একদম সাবস্ট্যান্টিভ অ্যাপয়েন্টমেন্ট
দেখুন কোথায় লেখা আছে
দেখুন
স্যারের এখানটায় থাকতে নয়টা যাওয়া খুব
এর একটা কপি দাও তো
আমার ওসিটা কোথায়
ইউসিটা বানাতে আছে
আচ্ছা হ্যাঁ ওই আমি প্যারাগ্রাফ আন্ডারলাইন করেছি
May I permit to press the judgment on this point?
এইটা
Written judgment of the Supreme Court.
ঠিক নাই
শুধু 13 14 পড়ে দিন না
This is reported in 2023. Well, no, my lord.
Plant.
We are learner.
This type of thing.
He is always privileged. Always.
Now, the floodgate will open.
Yeah, floodgate will open. That's a difficulty. We are saying. The floodgate will open, but a number of employees has been regularized, and this has been notification has 100 EMP has been declared to be ultra vires by the Samsung. That 100 EMP 1979 just placed before your worship. In 2010 justice
1990.
100 EMP ultra vires. Thumbs up. That's what that. Now the 2023 volume 18 SSC page 705.
ছেড়ে দিন, ওটা ছেড়ে দিন, ওটা ছেড়ে দিন।
No, just paragraph 11 and 14. Kindly see. Kindly see.
11, para 11. Para 11.
Para 11.
14, 13. বলছি।
Paragraph 13. Rule 13 of the said rule provides commencement of qualifying service. As per Rule 13, qualifying service commencement shall commence from the date he takes charge to the post which is first appointed, either substantively or officiating capacity. It further provides that such appointee officiating or temporary service followed without interruption by substantive appointment in the same and another post. Therefore, the service rendered on a substantive post or service rendered as officiating temporary shall be treated as qualifying service. Service rendered as a casual or contractual cannot be to be officiating or temporary service.
এটা ছেড়ে দিন, এটা ছেড়ে দিন, এটা আমাদের
Then,
Case which is
paragraph 14. High Court has committed serious error observing the service and temporary category will include the classes of temporary service such as casual and contractual. The High Court materially altered the observation the contractual service would be qualifying service for a temporary capacity. Then,
এই যে judgment of tribunal is
no.
so this is dealing
Either the rule not regulation provide the service rendered casual contract should be temporary service, not same will be counted for the purpose of pension and service benefit.
where rule 17 DCRB has been considered in this judgment.
No, this is.
Why are you placing that, sir?
No. What are the
That's under a different rule.
No.
Here your rule 17, read your own rule 17, what it says.
Ratio. Observe neither
That
the
ratio will apply to the facts and rule falling for consideration in that judgment.
particular case.
And in your judgment, we are considering rule 17 DCRB.
Yes.
So how this will apply?
No, what
Necessarily you are
are the ratio decision? Observe that neither the rule nor the regulation scheme provide that the service rendered
correct. So neither rule nor regulation. Here the rule is to be considered. How this will apply?
as casual or contractual should be treated as a temporary service or same
This
can be
judgment is
counted
hardly applicable
for
to
the
your
purpose
facts.
of pensioner service benefit.
May I most humbly submit one thing?
You have argued this. These are no application to your case.
And by this notification, about 69% were regularized.
judgment.
Give it. Let us have the judgment. We'll consider. Whatever you are giving, we will consider.
Kindly consider our opposition. Paragraph 4, 1A and 1B.
Yes,
Lordship,
your case is over. Please, this is not the way. Yes.
Similarly situated person will get the same benefit of your lordship's judgment or not, that will be another aspect of the matter. Even then, from the same list, I was appointed, page 26 of this WPS. In that case, serial number 35, now page 26 analysis.
You are at 26.
Yes, so, my husband is at serial number 27, Kader Ali. In that case, in this case,
Kader Ali.
Kader Ali. And in that case of his is 35, serial number, that your lordship just dismissed the recalling application out of which the order judgment was passed. Similar setup. Why? Prior date, 25 kindly see. What is the reason?
25.
25. And now they are mixing with their opposition. I shall place page 29. They admitted there.
Yes.
Page 25.
Yes.
In terms of geo number such and such, that you have already read. Such and such. The following master role personnels of the such and such engaged prior to 31st December 1991. Prior to. Our engaged 81.
No, they say that you fulfill all the requirement under EMP 100. That they have said.
Therefore, they cannot distinguish in that fashion daily wager, master role, contractual, or temporary. In that one of the judgments, your lordship, same argument was done. My lord asked Mr. Mukherjee to show the definition of temporary. Those are coming, nothing there. In that case, contractual. And same view has been taken. Your lordship's view is in concurrence with the Honorable Supreme Court has dealt with in the month of February.
Which judgment?
In that case, also contractual, temporary. Pension has been given in terms of that notification. As Rule 17, there also.
There also there was a
There
rule.
was. So I leave it to Lord Shimala. Nothing to be decided any further. Already the time they are trying to not daily wager. No, he is not the contractual. He is not the master role. So therefore, temporary status goes. I will judgment do. Judgment. This is one of the 29th of April latest judgment considering their rules. They are also one of Rule 17 also there.
And where is the provision under which they are declared?
Page paragraph 7.
No, we have seen here also it is Rule
Same
17.
thing, same.
Rule number is also same.
I checked it up just now.
Rule 17.
But I pardon to your lordship, but I cannot say much more than my vocal is today choked to some extent. Same.
Oh.
So well, nothing to be
No,
decided.
we want you to make some submission on that issue that is raising regarding temporary.
Yes, your lordship they already decided that.
Master
temporary-
role and all that is irrelevant.
Yes, that is there. Your lordship kindly see paragraph 18 of your lordship's judgment. In that case, also contractual.
We have decided this.
Yes, yes. Reported judgment it is. 2025, volume 1, CHN 796. Also, I have brought the website copy. That also plea was taken. That contractual service is not the temporary service. There, paragraph 15 onwards, kindly see. That was the argument. Your lordship discarded that. And counting from the earlier. Same query was put in that case also. And your lordship discarded that analysis. Already answered given. That is why I am saying so, not much more to be argued.
Paragraph 17.
7.
Again
18,
17.
18.
Again 17.
Again 17. I need not much argue. I leave it to your lordship.
And what happened? This judgment is holding the ground till date.
Till today. I have checked it up. No appeal before the Honorable Supreme
This
Court.
is of January 25.
Yes, well, this is reported is kindly I am writing 2025 1 CHN Calcutta 796. Volume 1 CHN. তুমি argument করেছিল
You have another copy of this.
Well, I'm 2 copies I have given. 796. The xerox করে নিব দাদা তুমি আর্গুমেন্ট এই নি এই বেঞ্চ কোনটা আর জানবেন আমার দরকার নেই একই জিনিস ও আমারটা কোথায়? আমার তো অফিস কপি। ও পজিশনটা ওদের অপোজিশন আমার আমার কপিটা এটা।
We list it under the heading for orders on 22nd
because of the same argument was done. And that has been SLP dismissed.
23rd. Don't want to take up these matters where we have to pass big orders. Because there are too many matters pending with us. So let's see if we get the time by on 23rd, we may pass.
I am paying for same judgment as well as Gita has been in on some judgments. Yet
Grateful, Your Lordship.
I shall rely on that.
Item number 225.
Grateful to
No, my lord.
Yes. See, we should start from the beginning. You please start from the beginning. Right now. Yes. The story starts from the charge memo.
Just I tell you the matter, just petitioner, a charge memo was issued. My first contention was that the charge memo was issued by a person who is not authorized to issue it. I will come to the fact, my lord. It is the first charge memo.
8/10/2004.
Yes, by a person who is not authorized to issue the charge memo, who had no jurisdiction to issue the charge memo. And second point of argument, I'll be showing the come to the point, my lord, that a decision of termination removal has been taken based on a charge memo which shows there are certain weaknesses. But facts remain, my lord, none of the witnesses were examined. There was no presenting officer. Therefore, in the absence of any examination being made, any witness being called on, which they relied upon, a decision taken. Then, my lord, is the first chapter, my lord. And then, my lord, there was an appeal. The appeal is there is no consideration of the appellate authority. It is simpliciter acceptance of a recommendation. And recommendation which has been made just narrated the fact, no consideration was there.
What was the relief in the first writ petition you filed?
Yes.
First writ petition was 5220 of 2006.
Milord, there are number of writ petitions. Milord.
4 writ petitions you have.
Milord, we can skip over. Lordship, do you have lordship on the last?
No, because the Honorable Single Judge was of the view that you have filed 4 writ petitions, you have not agitated this issue, therefore.
Yes.
Therefore, you can't say we can skip over.
Yes.
Whether that judgment is correct or not, we have to see.
Yes.
So, what are the 4 writ petitions for?
First, lordship, kindly turn to page 67. Charge memo. I'll come one by one.
No, first one is of 2006. 5220 of 2006.
Yes. Milord, may I refer the first before writ petition charge memo? Charge memo, page 66.
No, what are the 4 writ petitions for? First tell us.
Yes.
Charge memo we have seen, it is of 8th October 2004.
The writ petition comes subsequent to filing of charge memo. That's why I was trying to refer, my lord, the charge
Charge memo first.
first.
What is the page?
My lord, Page
319.
67.
Charge memo is page 67.
Yes, my lord. First order of suspension as page 66.
Yes, 67.
Yes, 67.
I got
66 with ordering portion. Who has issued me lordship kindly 6. Director in charge.
You are trying to go into the merits. We are telling you first, give us the background. What are the 4 writ petitions for?
My
We
lord,
will not simply ignore the order passed by the Honorable
no,
Single Judge.
that's true, my lord. My lord, first order, my lord. Writ petition, my lord. It will come to page 90. Before that, my lord, page 82, first. Page 82 is the first writ petition.
Page 83.
83. 83.
So this is the fourth writ petition.
That is the
This is the fourth writ petition.
first one, right? This is the first.
This is the fourth in the series, or this is the fifth?
I have referred the page. This is the first one.
This writ petition that we are considering, this is the fourth or the fifth writ petition?
Fifth.
Fifth. So where is the fourth one?
One, 37, 137.
So in the first one, a direction was issued to conclude expeditiously.
The last writ petition, my lord will be reading page 159.
No,
This is
that
the
is the third one.
this is the last writ petition.
So this is the fourth.
Fourth.
You said fifth, therefore we are asking.
No, this is the fourth, my lord. That is the order of Justice Dipankar Datta.
So this is the fourth writ petition.
Fourth writ petition.
So what happened after the third writ petition? The visitor has disposed of the appeal.
No, visitor, in my submission would be visitor
Not
himself.
submission. What is the fact? In
Yes,
compliance of the third writ petition, what happened?
then matter was referred to the visitor for a decision.
Yes.
Visitor itself is not decided the matter. MHRD Secretariat Department send a proposal to the visitor. Visitor simply accepted it.
All right. So where is that order?
Yes, Lord. Lord, you kindly turn to page second volume. Page 237 to 242. 298, volume 2, my lord. Volume 2, page 298.
Yes.
And Lordship kindly.
So what is the relief in the present rate petition? Where is your prayer in the present rate petition?
Prayer, my Lordship. Page 56, my Lord. Of the volume 1, page 56.
So quashing of the disciplinary authorities order and the appellate order. And in your writ petition, where have you said regarding the charge memo being without jurisdiction?
Lord, page 88. Yes, my Lord, page 59. Page 49, paragraph 59.
Yes.
And grounds, my Lord, all the grounds I have taken. And my Lord, on the last occasion also wanted to me what any course of the proceeding, appeal, remanded, whether you have taken this point of jurisdiction.
Hmm.
Page 88, my Lord. This point was also agitated. 7. Though the petitioner is not appointed by the director till while acting as director or officiating annexed director has not only initiated the department proceeding by or dealt with the same and also conducted the same by imposing penalty of removal against your petitioner, which is against the principle of law.
Yes.
And also, my lord, in the writ petition before the appeal before the appellate authority, before the visitor, by making a supplementary memorandum of appeal, my lord, I took this point specifically, raising this jurisdictional point, which, my lord, I crave leave in the writ petition. That's why, my lord, in the supplementary affidavit, I have referred those documents saying that these points were taken.
In your appeal,
Yes.
where is that?
My lord, lordship, kindly turn to my supplementary affidavit. Just a minute, help me. কোথায় গেল? Facts of the case. জিজ্ঞেস করতে ওটা। Page 40 of the page 39. না না কোথায়? কিসের?
You have raised this in appeal.
No, initially, yes, that's true. That's true, my lord. I have raised,
This is the appeal. What are you
Yes.
looking for? See, page 88 is your appeal.
yes, that's correct, my lord. The point of jurisdiction, initially we did not raise. Admitted position, I cannot improve on it.
So in appeal, you have taken it.
Yes,
Appeal is at page 88. What are you looking for?
yes.
This
We
is
have,
your appeal.
yes, we have taken this point.
Yes.
In all stages, my lord, we have taken this point.
All right. You have taken it. Now let us see first that point. It is on based on which which rule?
Page 66, my lord has seen it. 67, who has issued it and under what rules they have it.
Page 66.
Page 66. Starting point is page 66.
We are not asking you that. We are asking you According to you, who is the competent authority?
Yes, Lordship kindly turn to my supplementary affidavit. Initially, it was under, before it was elevation as an NIT, it was under a college. It was a college, society.
Under the university.
Ultimately, it became a deemed university status. Initially, it was a college. When the petition,
If it was initially a college, then it must have been under a university.
Bardhaman University.
So under the Bardhaman University till which date?
My lord, till 2003.
Then
it became Regional Engineering College, Durgapur. Then it became NIT.
so when it became Regional Engineering College, it was still under the university.
Yeah, under the university.
It was declared an Institute of Excellence.
You see,
Thereafter, when?
thereafter, my lord, NIT in 2003.
2003.
Yes.
So 2003, you said it came under Durgapur. It became a Regional Engineering College, Durgapur.
Now, initially it was a regional engineering college, my lord. First, then it became NIT from 2003, 9/11/2003. Initially, it was regional engineering college.
And you were appointed there prior to this change of status.
Yes.
You were already there before it became NIT.
Yes.
And the charge memo has been issued in 2004.
2004.
Therefore, after it became NIT, charge memo has been issued.
Yes.
Now, on 9/11/2003, there was any transitory provision regarding the rules governing his service?
When I was charge seated, my lord, rule under the present body came into force.
Rule under?
Rule governing the NIT came into force.
So, where is that rule?
Lordship kindly turn to my affidavit, page 37.
Affidavit.
Supplementary affidavit.
So, same as IIT Delhi.
Same as that.
Yes. So, where is the IIT Delhi rule?
Then Lordship kindly next page, 39. This chapter 5 came into force.
Yes.
5.2 at page 40.
Five 5.2 is the appellate authority.
5.2 deals with my appellate authorities. Who is the appointing authority? Disciplinary authorities, 5.1, prosecutally starts with for the following are the disciplinary authorities, page 39, for the various categories of staff. Director in case appointed by him, and board of governors in case of member of the staff. Therefore, my lord, board of governors is the appointing authority in case of member staff.
Member of the staff has been defined.
Staff means, my lord, academic staff.
Where is that? So you are appointed by the board of governors.
Board of governors.
How you can be appointed by board of governors? Board of governors would not be in
Yeah,
existence.
yes, I will be showing. Even when I was a teaching staff of the college, they are also a board of governors of there. I will show 19.1 says that I was appointed by a board of governors. When I was under
College?
yes, even in Ari College. Ari College Society Registration Act is there. I have also, I will show me lot. That said 19.1 basically picks up in case of teaching staff, governor, board of governors. Here they are also governor. Same thing carried forward under the present rule. Therefore, my lord, 5.1 I have shown, 5.2 in case of, that's why it was referred to the visitor.
The earlier chapters you have not annexed.
All chapters have, every chapter.
No, this is chapter 5. It starts from chapter 5.
Chapter 5, disciplinary, this is applicable, my lord, that's why I am annexing.
No, it must be containing the definition of board of governors, what it is to comprise of. There may be several other propositions we don't know.
My lord, page 24, Lordship Policies, National Institute of Technology, Durgapur, Memorandum of Association. কেন দেখাবো? And page 30 deals with appointments.
All right, so according to you, 5.1 will govern you. Yes, let us proceed.
Therefore, my lord,
And charge memo has been issued by
director in charge, page 66.
page
66. Page 66 is this is suspension order, director in charge, and charge memo is 67, followed by charge memo. That is also director in charge. And final order of termination, removal of service.
Yes.
by director. Therefore, suspension order by director in charge, charge memo by director in charge, and ultimate order of termination by director. That is at 125 page.
Yes.
And Lordship, another thing, Lordship kindly sees the rules followed, under which rules that charge was initiated, charge was disciplinary proceeding. Lordship kindly takes the trouble to see, just for a while, page 67.
CCA.
67, CCA.
Yes, we have seen
Yes.
it.
Rule 14.
How it can be when there is it is governed by the IIT rules, then how?
But it has been followed. It has been followed. All the rules clearly says who would be the appointing authority, who can initiate it.
We
But
don't know where is the appointing authority.
appointing authority, I have shown, my lord, in case of member staff, it is the Board of Governors.
Where is that?
That's why in the rules itself I have shown, my lord.
We have not seen.
Then Lordship kindly, then if supplementary affidavit, even allow me to go back the initial appointment. Rule 19.
It says disciplinary authority. It does not say appointing authority.
Yes, I will be showing to your lordship. Page number 19 for a while. Rule 12.
Yeah.
12 says, my lord, powers and functions of the board. And rule 9, lordship kindly sees, to create teaching, administrative, technical, ministerial, and other posts under the college and make appointments thereto, and management of the affairs of the college, and to regulate their recruitment. Rule 12 prescribes the powers, functions of the board. And under 19 meters specifically said, my lord, rule 9, sub-rule 9, the Board of Governors is the.
Yes.
Rule 19, page 30, revised memorandum. Rule 19A, page 30. my lord. The board for the post of lecturer and above academic staff or those posts in academic council is etc.
So this is a memorandum of association.
Yes, my lord.
What is the date?
I am giving the date.
8/4/2003.
Yes, sir.
But you said it became NIT in 9/11. This is of 8/4/2003.
Yes.
What years?
Yes, 8/4 before that. Thereafter it has become NIT. All the staffs who were there, they have been absorbed under the NIT. With the same status, they have been absorbed.
You told us that in November 2003 it became NIT.
Yes.
Then how this memorandum is of April 2003 prior to becoming of NIT?
Memorandum has been made. Thereafter,
Huh?
memorandum has been made. In the process of memorandum has been made. Thereafter, it has become.
Because it was to be declared as NIT.
Yeah, that's
All
why.
right. Yes. So that is your first point.
That is my first point.
Yes.
That admitted position, my lord, if I have been, a proceeding has been initiated by a person who is not competent, had no jurisdiction to it, but it has been done.
Yes. Next point.
Next point would be involved. My lord has seen the page 67 charge memo. There has been 3 witnesses referred. But my lord will find none of the witnesses were examined. There was no presenting officer.
Yes.
My lord, here I join is. They
Where is the inquiry report?
inquiry report, my lord, at page
You must have been given a opportunity to make a representation against the inquiry report.
I have given.
Where is that representation?
So far as my lord, reply to the charges, I have replied a bunch, my lord. It was not a part of it. My lord, on the last occasion, I have submitted it.
We are asking you. You say that a procedural infirmity vitiates the inquiry in as much as there is no presenting officer and no witness was examined.
Yes.
Then you must have raised this in your representation made against the inquiry report. Where is that
No,
representation?
no, my lord, I cannot improve on this. The physical, this point was not before the inquiry officer that I know it. That was not there.
Please listen to us, then respond. If the inquiry officer has committed such an infirmity, you must have pointed this out to the disciplinary authority while making your representation against the inquiry report. Where is your representation?
Yes, I sorry. Yeah, I follow. Huh? Page 104. Order dismissal. आपने
Page 104.
no.
Yes, sir.
No, supplementary affidavit 104. I have made a mistake. And page 8.5, Lord, I have taken this, that the petitioner conclusively was never allowed to use his witness, albeit there was no whisper of any statement made by witness, which is violation of rule, statute, such and such. In supplementary.
Just now you submitted, there was no presenting officer. Just now you submitted, they did not examine any witness. Where have you raised this point? Please show us.
I have says 8.5 that petitioner conclusively was never allowed to use his witness, albeit there was no whisper of any statement made by such witness which is a violation of rule. I have said so, my lord. In this word, I have said so. But the facts remain, it is on record, my lord. From
What fact, this is the record. That's why we are asking you to show
what I
us.
submit, my lord, that there was
What record?
no witness was examined. That
You have not said no witness was examined. You have said you were not allowed to examine witness.
well, this
You
is
have not said that they have not
the-
examined witness.
from the findings of the inquiry officer, my lord.
Everything presumptuous.
No finding from the inquiry officer, my lord, will get it that there is no examination of any witness.
So you are not required. If you are not aggrieved, then what is to be done?
There was no, my lord,
If you are not aggrieved, then what is to be done?
my lord, they have to prove their case by
They have proved it and you have accepted it.
my lord, I did not accept
So
it.
show us where you have said that there is an infirmity. Why don't you understand? A simple query we are asking you. You are not arguing an appeal over the disciplinary authority. We are not sitting in appeal. The writ court does not sit in appeal. These are the procedural infirmities, non-appointing of presenting officer. If it is found it is correct, surely the inquiry would be vitiated.
Yes.
But where have you said? What do you mean? Yes, it's all in your
My
mind, or we have to see it.
my lord, from the order of the inquiry officer itself, and from the order of the disciplinary itself, my lord
All
will
right,
get
you
it.
proceed in your own way.
My lord,
Yes.
my lord will get it.
No, you
that
proceed
there
in
was
your own.
no presenting of.
Show us from anywhere.
Lordship, kindly turn to report of the inquiry officer.
So you have not raised any issue in the representation. You have not raised, then what is it? There is nothing. You are not aggrieved by the procedural infirmity, then what is to be done?
Lord, inquiry officer report is a part of record. My lord will find.
No, it is not. We are not sitting as appeal. Please try to understand your limitation.
That's true, my lord.
I am not going to go through the inquiry report unless you make out a case what is to be examined. You are not showing us, we are asking you. Everything you are making submission but not corroborating with anything. 2 points you have raised, we are asking you to show. Competence of the disciplinary authority, you have argued, we have seen it. Now 2 more points you have raised. No presenting officer, no witness. Where is this? No witness.
No witness, it will appear from the finding of the inquiry officer itself. He has not relied on any witness.
He has not relied, he has
Any
concluded.
witnesses.
He has concluded. Then you were given an opportunity to make this representation. So you will not raise it. And then the writ court has to go and look into the inquiry report.
No, my submission will be below. These are apparent on the face of the record.
Not apparent. It is
These are
not apparent.
that a consideration made without going on to any.
Anyway, we'll consider your representation, whatever you have said. What can be done if you are not interested?
My lord will find from the report of the inquiry officer, my lord will not find a semblance of that they have considered any witness, nor there was any presenting officer. This is apparent, my lord. At least my lord will say that in report of the inquiry, it doesn't speak of consideration of any witness.
Which date did you appear before the inquiry officer?
May 5th, 2005. Only one. Age 86.
Where is the inquiry report?
Page 101, my lord. Page
101 of what?
volume 1, my lord. Volume 1, paper. কি বলছে? পয়েন্ট কনসিডার পর একটা জিনিসের সাক্ষী আলাদা।
Yes.
And my lord, apart from this basic point on the procedural aspect is concerned, my lord, I have also referred the appellate authorities order. Appellate authorities order. Whether there is any consideration of anything, my lord.
Where is your appeal?
My lord,
Page 88.
Huh?
Page 88. Where is your appeal? Is the date of the inquiry report. So inquiry report is of 7/5/2005,
Yes, ma'am.
and you have submitted your representation in October 2006. Why? So incompetence of the disciplinary authority, no presenting officer, no witness. What else?
And another thing, my lord, so far as my lord, my submission is that I reply to the charges not properly considered. Because this point I preferred in appeal, because appellate authority had no occasion to deal with the matter, it remains unresolved, my lord. What lordship have you seen the order of the appellate authority? There is no order as such.
Yes. Yes, we have already seen the appellate authority.
My lord has seen, is there any consideration of anything?
Paragraph 3, relying on paragraph 3. The
Here is your paragraph 3.
We have seen that.
Simplicity. Just he has quoted something and it has been.
What
There-
else?
These
What
are
else?
these are the three things, my lord.
That's all?
I want to submit. Apart from that being on merit, I will be submitting, my lord, that my point.
This is not on merit.
That is the problem I face, my lord. My lord will not go into this question.
Yes.
These are the 3 points, my lord, basic points I want to raise before lordship. That these are the things practically high-handedness is
All
happening.
right, we have seen incompetence of the disciplinary authority, no presenting officer, no witness. Appellate authority's order shows no consideration by the visitor. What else? Anything else?
And even the appellate authority, not only visitor, my lord, the visitor has accepted it. It has been recommended. Recommendation order I have showed to you. Recommendation doesn't speak of any consideration of disciplinary authority order.
All right. What else? That's all.
These are
Yes. Regarding competence, what do you have to say?
My lord, there were certain Board of Governor minutes of meetings which validated the appointment of the director as the inquiry officer in this particular case. Also, the rules were laid down that the CCS rules would be followed as the rules for the inquiry.
So this all took place prior to issuance of the
My-
charge memo,
My lord, it was ratified after, I'll just,
post facto, or
my lord, I'll just give the dates.
ওনারটা কই? ওনার
So you can address us tomorrow.
My lord,
Tomorrow you can address us.
I will take, my lord, 30 minutes and,
Whatever,
my lord.
you may take 30 minutes.
Which starts at page 76, my lord.
Yes.
He was a witness, my lord. How he can
Please, this is not the way. Yes.
My lord, there is mention, although being one of the prosecution witnesses,
Page
performed,
78.
page 78, my lord, performed as presenting officer. My lord, with regard to prosecution witnesses, since the charges were admitted to, which is why there was no
That
need,
is why we asked him repeatedly.
my lord.
He cannot improve the records, obviously. So the presenting officer issue, we are not very sure until now,
My lord,
because the inquiry report records that there was a presenting officer. Issue has not been raised in the representation. Issue has not been raised in the appeal. Neither of the two documents he has raised this issue,
my lord.
but he is arguing it. So we'll consider.
Also, my lord, with regard to the first point about jurisdiction, I will show the dates which clearly show that the Board of Governors had authorized the director. They had laid down the rules that were to be followed, and thereafter the inquiry was proceeding with a report to be presented to the Board of Governors whenever they met. The reason being that the Board of Governors comprised of members from various quarters of India. They were mostly visiting faculty, and therefore they delegated. They also have, there is a mention, my lord, in as part of the paper book documents, where the rules allow the Board of Governors to delegate certain of their
That
powers.
provision is there.
My
So
lord.
we'll see.
My lord.
We don't know.
My lord.
Maybe.
My lord, 2 p.m. I have another matter.
You want it in the first half?
My lord, just. My lord, if this matter could be taken up first half, my lord, because
Keep it in the first
I'm grateful.
morning. Ah, yes.